The government is to face an action in the European Court over the killing by the SAS of 3 leading IRA members in Gibraltar 5 years ago. The European Commission on Human Rights has ruled that a case brought by relatives is admissible. It will mean a full investigation into the shooting of Danny McCann, Mairead Farrell and Sean Savage.
When Danny McCann, Mairead Farrell and Sean Savage were shot dead by the SAS in Gibraltar in March 1988, there was uproar from civil rights activists who claimed 3 unarmed people had been the victims of excessive force. But 6 months later, an inquest jury in Gibraltar returned a verdict of lawful killing, and as far as the government was concerned, the case was put to rest. However, today's recommendation by the European Commission that the case be referred to the European Court at Strasbourg has again put all the evidence on the table. Although a ruling cannot go beyond this specific case, it will have the power to say whether the shooting was justified in law or whether the SAS can be said to have used excessive and unnecessary force. Lawyers and relatives are hopeful it will be able to unearth new evidence because, unlike the inquest, there can be no use of public immunity certificates. Relatives and Sinn Féin have welcomed today's decision. Lawyer for the families, Paddy McGrory, says it's a welcome step forward.
I'm pleased for the families. They have always sought some sort of impartial international inquiry into how their people died when they were unarmed. And now they've got that, and I'm very pleased for them because it's been a burden they've carried with considerable dignity for some years now. It does mean they have to face a very, very close scrutiny of what actually happened in Gibraltar, which is something which they've used every legitimate legal stratagem open to them to delay or prevent. And they have so far now got to the stage where they'll have to face this inquiry, and that's all to the good. I think that it can do nobody any harm to have the truth come out.
Lawyers argue the government, in tasking the SAS on the Rock to take out a suspected IRA unit, was breaching Article 2 of the European Convention on Human Rights, which guarantees the right to life. The hearing in Strasbourg could take up to 2 years to complete.
And earlier this afternoon, I spoke to Tom Haddon, a lecturer in law at Queen's University. Tom Haddon, what happens now?
Well, nobody knows quite what is going to happen now. What has been decided by the Commission is that there is a case to answer. They have apparently asked for further documentation, I think from the government side, and when they get that further documentation, they will then decide whether or not there has been a prima facie violation of the Convention. Even if they decide on a majority against that, it seems to me to be likely that this case will proceed to be ruled on by the court.
So at this point, it is not certain that it will actually go to court?
It's not certain, but I think it's likely. The Convention lays down that at this stage, if the Commission finds there is a case to answer, they have to make themselves available for a friendly settlement. I should have thought that it's fairly unlikely that the complainants in this case will want a friendly settlement. And I think it may also be that the British government would like a ruling by the court on this matter.
By friendly settlement, what do you mean?
Well, a friendly settlement would normally be a compensation payment by the government and an undertaking that the terms of the Convention in relation to right to life would be adhered to in the future.
So if this does go all the way to court, what form will that hearing take?
The court hearing would be more public than the Commission hearing. The Commission hearing is theoretically confidential, though the fact that we're sitting here talking about it today means that it's not actually as confidential as it's supposed to be.
What teeth would this court have?
The court can make a ruling. If it decides the government is in breach of the Convention, it can order compensation, and it can also, by the fact that it has made its ruling against the government, put quite strong pressure on the government to change its law or its practice.
Tom Haddon talking to me earlier this afternoon.